Welcome back to Settlement Nation podcast. If you're one of our loyal listeners, then thank you so much for tuning back in. I'm Courtney Barber, joined by my co-host Chris Bua, as well as a kick-ass trial lawyer out of Denver, Colorado, Jason Jordan from Jordan, Herington Rowley. Now, Jason has obtained tens of millions of dollars of settlements and verdicts for his clients, including a $26.5 million settlement for a burn victim and also a $20 million settlement in a brain injury case. He has had success in both federal and state court, was awarded New Trial Lawyer of the Year in Colorado, and also is the president-elect for the CTLA. And he is a great guy full of energy and a super awesome friend as well. So welcome, Jason.
Thank you, Courtney. Good afternoon.
We are so happy to have you. I've been looking forward to this episode. I don't know if you know, for a long time since we've had the podcast. I kept saying to Chris, when are we going to get Jason Jordan on? Because we need a little bit of flavor. We need some energy. I think you're going to bring that to us today. So just to set the scene for everyone who doesn't know you, tell us a little bit about your background and how you became an attorney.
Sure. So I was born and raised in New Jersey, mainly Italian and Sicilian. So I have a little bit of that spice, I think, that you were talking about. It kind of comes natural to me. About 2 days after I graduated high school in New Jersey, I moved to Colorado. My parents had already moved out a year before, and I followed them out. College, did law school in San Diego, and really was going to law school as like the next logical step in my mind, because I wanted to become a politician. As horrible as that may sound to some people, it's the truth. And getting out, I'd worked for some politicians here locally in Colorado. I'll never forget one gentleman told me politics is a dirty fucking nasty business. He literally turned to me and said, "Son, politics is," at a political dinner. And that always stuck with me. And when I went to law school, within the first month, I had an offer for an internship at a firm where everybody there graduated from our little law school, and it was a personal injury law firm that also did workers' compensation. Thankfully, I never fell into the work comp. That's not an avenue I would ever really wanted to pursue myself. But it was an eye-opening experience for me. The first day I was there, they took me to a mediation. The second day I was in a deposition, and I started putting the pieces together and realizing like really quickly, hey, this is something where I can help people more than I probably ever could in politics. And I can make a hell of a damn good living doing it. So I decided to take one of my father's friend's advice. I'm the first lawyer in the family. My father's friend told me a piece of advice before I drove out to law school. He said, "You learn to think like a lawyer in law school. You learn to be a lawyer in a law firm. Get a job," which is why I took that internship in the first place. So I immediately started to get as much experience in that law firm. It's called Herington Rowley out in San Diego. Dave Herington really kind of took me under his wing and taught me everything that I learned until I graduated law school, to a point where I graduated. My wife and I had one kid and one on the way. I had a job lined up at HRO. We decided to move back to Colorado just because we could afford our lifestyle that we wanted much quicker, we thought. And then I made the decision that I'm just going to go out and do this on my own. So I literally just started my law firm right after, I came out here, I took the bar, passed, and I started my law firm the next day. And it's been going since. I started out from, in my house to, on the 10th floor of the Quadrant building here in Greenwood Village. And it's been a ride, I'll tell you what.
So let's get into a little bit on the tactical side, Jason. So this is Settlement Nation, so we love settlements, but we know that verdicts also are huge, and a lot of the biggest settlements are preceded by a big verdict. So we wanted to talk to you a little bit about what's your process of deciding whether to take a case all the way to trial or settling, and what are some of the factors that are most critical for you? And then lastly, how much do you rely on your clients to make the decision whether to settle or go to trial? Like, do they say, like, I want to end this, and you just, even though it's worth more, you go for it, or you just tell them no, like, I want to go all the way with this case?
Right. Well, that's a good question. I mean, at the end of the day, the decision is always up to the client, right? I like to hope, and I think we do a pretty good job of having good client control and get the trust of our clients that they are oftentimes telling us, hey, I'll do what you say. I'll listen to what you say. Now, occasionally, of course, you're going to have that person who's just absolutely terrified to go to trial. But backing up to what you were first saying about the settlements versus verdicts, yeah, verdicts are going to drive that, right? I mean, if you have multi-7, 8-figure verdicts under your belt, it's going to drive settlements down the road. You're not going to have to try as many of those cases down the road. In fact, I went through a period just before COVID. It kind of pissed me off where I was in this groove where I was just trying as many cases as I could, right? I think I did like 8 or 9 in 1 year, which in Colorado is quite a bit, I think, for doing civil law. It's not as much as someone like Rowley would do back in the day, but it's a decent amount. And it's a lot of work, and I was having fun doing it. But really over time, the ones where they give you a chance, they give you a shot to knock it out of the park, those were getting fewer and fewer in between. I started to be left with nothing but like small cases that other lawyers in my law firm were working up, and I just wanted to get in the courtroom and try the case. So I'd go, and I had multiple, disputed liability capped cases against governments or something like that. And I got to a point where I was like, all right, I'm not going to do this anymore. I'm tired of trying these like smaller, disputed liability apportion type cases, but they're fun too sometimes. But I had a bunch of them right in a row. But I think the point of that story is just that a lot of the good ones that maybe 10 years ago, 12 years ago, 15 years ago, I would have had an opportunity to go try that case. They paid enough money. They're paying $2 million plus on a back surgery, right? I mean, I remember I was getting ready for a trial where they had $2,050,000 on the table for a lumbar surgery. And I was getting ready to go to the pretrial on Friday before the Monday trial. And my wife was standing next to me as I was putting my tie on. And she just said, "You're an asshole. You've got good money on the table." And I was like, all right, if she's telling me that, then maybe I should back off on this one. And, it's good money for the case. And she knew it. And so did I. But I had a really good set of facts. But I guess my point is, you got to start out with the verdicts. I mean, you really do. And it's because the insurance carrier has to know that you, the attorney, not only can you and will you, but you've got a real good chance of being successful and getting a higher number. How do I make the decision was your next question, whether to go or not go. I think there's so many things that go into that, like the optics of like who your client is, what jurisdiction here is, what the story, who the defendant is. There's a lot of things that go into that. But generally speaking, what I tell my clients is if they hang the fruit low enough that it makes your job difficult, and I'll even tell mediators this when we're told to go to mediation, I'll tell them, I'm not going to counter that number. Why would I counter? I could beat that number every day in court. I'm a hero to my client. No matter what happens, I'm going to beat that number. So I start negotiating knowing I'm not going to get them where they need to be, but they might get close enough to be hanging that fruit low enough that now it makes my job harder to have that conversation with my client. Screw it. I'm not countering. I'm done. So that's how I sometimes will approach that type of a situation. Again, optics are everything, right? I mean, it could change given any case, but that's my general stance when they come in and they offer kind of crap money and you're debating whether you go to trial or not. Now, when they come in and they're starting to offer reasonable money, or you leave that mediation and they call you up and, hey, look, we really want to see if we can get it done. I'm not going to make moves on that. I'm just not. We had a case that we hit about a week from trial. It was a brain injury case for $20 million in Denver that we settled, and just shy of trial. And I'll never forget, they had put $10 million offer on the table, and I never responded to it. And at just before the pretrial conference, their Manhattan lawyers call us up, and he's talking to me about if I'm going to make a counter. And I had that conversation. I told him, why would I make a counter? I'm going to be 10 million all day long. You're giving me a chance to go for 100 million. Some other things were said and some choice words by me to the opposing counsel. He tried to say to me, I said, why would I bid against myself? And the guy said, well, I'm kind of in the same boat. Why would I bid against myself? And I lost it. I did. It's not. I had a nanny in the kitchen filling up milk bottles for my kid, and I'm sitting there screaming, "Because I got you by the fucking balls. That's why. What do I have? Asshole written across my forehead?" And I hugged him eventually. I went to the pretrial conference. I won every motion that was being argued with local counsel. Hopped on a plane, went to San Diego to go see some friends, and next morning woke up. I had a $17 million offer in my inbox, and then I knew it was going to get settled. But I just find that one kind of interesting in terms of, telling younger attorneys that, especially when you have those kind of facts and that type of a case. I had 10 mil on the table and I refused to negotiate and told them, no, I'm not going to counter. They knew that I was in the driver's seat, and they showed me that by putting another 7 on the table without me even making a move on their 10. So it really comes down to the optics of each case and client control, having a good rapport with your client and, making good decisions based on all those things.
Right. And this is a perfect lead on question from that. Speaking of those like big multi-million-dollar settlements and verdicts, Jason, why do you think you're able to ask for and achieve such big numbers?
Well, I think it really comes from two things. I think one, the confidence and the belief. So maybe three things: the confidence that you can actually get the number, the belief that the case is actually worth it, and the track record and the history of actually getting big verdicts and going in there on zero offers and hitting out for millions of dollars. I think a combination of those three things make it so that when you're in that position and you're actually negotiating that type of a case, they know that you're serious, that you can hit that. They know that you can hit that, and the case could be worth that or is worth that. But the bigger thing about what I said before too is, especially when you're in trial, I know this is settlement discussions, but when you're in trial, I had a younger lawyer call me up not too long ago, and she was talking about a brain injury trial she was about to go to in Denver. And I was telling her, go sit down and like meditate over this. Think about the actual value of this and think about the harm that this person has to deal with for the rest of their life, and sit there and really meditate on it and get yourself to a point where you actually believe it is worth 15 million or it is worth 20 million. Whatever number that you want to be able to ask for, you have to believe it yourself. If not, the jury's going to see right through it. So I think there's a combination though of what I was saying before, the idea that, you have to have the confidence, you have to have the belief, and you have to have the talent and the skill in the courtroom to be able to put some of the fear of God in these people.
Yeah. So speaking of cases, is there kind of a memorable case that sticks out in your mind from your career so far?
There's a lot. I mean, there's a ton. I think anyone that's been doing it as long as I have and who's done any of these podcasts with you folks would say the same thing. One that sticks out for me, it wasn't even that real big of a verdict. It was a single level low back surgery. I think we got like 1.4 million or something like that, but it was in a very conservative jurisdiction, Douglas County, Colorado. I had a defense lawyer who was a little long in the tooth, older gentleman from Chicago who's known to be a little bit of a bully kind of a attitude kind of guy. And from beginning to end, the trial was just absolutely horrific dealing with this person. Even defense lawyers have made jokes with me about it. And got to a point where he's taunting me. He's like, and I'm just smiling. I got under his skin so bad with questions with one witness that even in front of the judge, he's dropping F-bombs at me, and I'm turning to my associate, my paralegal, going, "Hey, we're getting under his skin now, aren't we, boys?" Just like having like one of those experiences. And then he was trying to shave like $300,000 in medical bills to like $5. And the juror question came in that said, if we don't think all the bills are related, do we have to give all the bills? Well, of course, he's thinking he won and everything's great. I think it was $390,000 in medical bills. And he's smiling, he's laughing, he's like taunting me as he's walking out of the courtroom. And he comes back in when the verdict comes in, which was like 10 minutes later, looks at me, smiling. "It's Miller time, baby." And it's just a piece of work. And of course, the verdict comes in. They shaved $2,000 off of the economic damages and wound up with like a $1.4 million verdict. He just packed up his shit as soon as he could and ran out the door. That was one of those where it was like, I mean, it was a bunch of my friends were trying to convince me to send him a 6-pack of Miller, but I decided not to. I thought I'd take the high road on it, but I probably should have. But yeah, that was one of the memorable trial experiences. I think some of the larger cases, obviously, that you deal with in your career that leave a lasting mark on you, settlement or trial wise, where you're really helping people through, severely catastrophic injuries. Those always stick with you for sure.
Or you could just buy yourself a 6-pack of Miller and drink it.
Yeah.
Apparently it was Miller time.
Yeah, apparently it was. Yeah.
So Jason, on the topic of trials, I know, with your background and stuff, you seem like someone who has routines and likes to stick to different routines. What are some of your must-do trial prep that you always sort of execute as you're getting ready for trial?
It's actually it really depends, honestly. Not about even the case. It depends about how far in between trials I am. But generally speaking, I will, first and foremost, I'll go through the file with the lawyer in my firm that has pretty much worked it up, and I'll figure out the most important issues that I need to know. And I generally know that before we even start trial prepping. So that's kind of like a no-brainer. I love to go through Rowley's Trial by Human book and David Ball on damages And I will go through, and I have so many markings from each trial and highlights with different colors with tabs on it that you pick out a little nugget every time that's going to help you given the facts in your case. That's been something that I've done since I started trying cases a long time ago. Is I will go through those things and just kind of reread them. It's always a good little refresher, and not even read it word for word, page per page, but scan through stuff. Like I know the voir dire is going to be an important part because of specific issues. I'll go through and read that again, and I'll usually pick up a little nugget, that sort of a thing. Sitting down with my client, I'm a big believer in going to their house if I can. I'll sometimes call up my client and tell them I'm coming over for dinner. You can cook, or I'll bring in takeout. It's your choice. But you pick up these little nuggets. I always give people this example. I had a trial about 10 years ago where went to my client's house, sat down, and there was a picture of my client and her father in Egypt outside the pyramids. And it was just a beautiful picture, the pyramids in the background. And I said, "Oh, no way, you were there." And she's like, yeah, that's me and my dad. And we were supposed to go back, and this accident happened. I had to have the surgery. By the time I recovered, he had a heart attack and died. And I was like, oh my God, what a horrible, horrible story, right? Well, guess what? Had I not gone to that house and saw that picture and sparked up that conversation, I never would have known that little nugget of a story, right? And I think you can't rely on your client to tell you every single bit of their life or what it is that you're going to find necessary to tell the jury. You have to really go digging. And a lot of that comes from getting to know them, getting close with them, going to their home, meeting with some of their family members. That's always something that I do in almost every trial. I try to make sure that I do that. Some of the other things really are working with my audio-visual people. I like to make sure I have specific pages of specific exhibits that they know what's important in that exhibit, so things move slowly. The last thing you want to do is look in front of the jury like you're unprepared because you can't get the audio-visual guy to see what it is that you're trying to talk about to blow it up on the screen, right? Like a part of a record or something, by way of example. So that's something that I always try to do. And I also will use them as like a little bit of a free jury consultant because those guys see more trials than any of us. So that's like a couple things. I could probably talk for an hour on that, to be honest.
Well, that's good advice there. What about, we have a lot of younger attorneys that listen to the podcast. What do you look for when you're adding an associate to your firm? What are some of the traits or attributes that you look for in that attorney?
It's a good question. Definitely someone who's aggressive and who really wants to be going in and trying cases. That's something that is a must in our firm. I also look for people that I know that I can trust, who can actually litigate cases that I don't have to be in every deposition if I don't want to or if I can't. I try to surround myself with people that I know are, better than me at certain things, right? Like my forte, if you will, is trying cases, right? Is being in front of a judge, being in front of a jury. I'm not the best brief writer. I can do it. It's probably just going to take me a lot longer than, Michael Douglas Harris in my office, So, I mean, I try to find, fill holes in terms of my weaknesses, number one, but also, if you can be that person that has that brief writing, that type of skill where you're great at taking depositions, you're great at motions practice, and you can try a case and you're good in a courtroom, that's the kind of lawyer that, we're always looking for, to be honest. And they're, I don't want to say they're hard to come by. I think a lot of people just haven't had the chance to get in the courtroom and understand and get comfortable and confident in their abilities in front of a jury. But we look for people that are talented, obviously. Sometimes it's, someone who's very good at building cases and taking depots and litigating the hell out of it, but might not be the best in the courtroom. That's fine. I'm okay with that, right? Sometimes we look for people that are great trial lawyers. It just kind of depends what our need is. But if you could be both, that is a rare trait. Yeah. And I think I have some, so I'm very blessed.
So I know with Trial Lawyers for Justice, you co-counsel a lot of cases across the country. How many of your cases would you say roughly percentage-wise are co-counseled? And what tips do you have for our listeners on co-counseling cases effectively?
That's a great question. So first of all, from our perspective in our firm, it's increased continuously year after year for the past probably 10 years, where I would say a good 50 to 70%, sometimes even higher, come from other attorneys, whether it's in Colorado or I think right now I'm in like 12 other states litigating around the country. They're usually like multi-8-figure, very large dollar value cases. So it's increased over the last 5 years. It used to be like maybe 10 at a time, something like that, maybe 25%, something like that. But yeah, so that's gone up. But in terms of what to look for, are you asking for the person who's referring or the lawyer that's receiving the co-counsel?
I guess the one that's receiving the case. Do you have any tips on how to work together with
Yeah. So first, that's a great question. Then first, you really want to make sure if you have other lawyers that are bringing you cases, obviously you want to vet them very carefully. You want to make sure that it's worth the idea of splitting your fee, et cetera. If you're not going to be able to add value to it, really, then be honest about that up front. I think really what we try to do is also figure out a division of labor up front, fee split, cost sharing up front. Sometimes we give options, if you want to be involved in the case and really do more than the average person does. A lot of people just want to sit in on some depositions and go to some court hearings and help prepare for depots and stuff, but don't really want to take any. So we'll do different arrangements, but I think you need to get that done up front, obviously. Do that at the beginning of the case and, make sure that your referring attorney is being honest with you. I can't tell you how many times it's, oh no, I really, I want to be involved. And it's like, I've sent you the protective order. I don't know how many times and you haven't, said a peep about it back to us. So we're just going to go ahead and stipulate to this thing. But, so it's one of those things where common sense is obviously, at the forefront of our mind in terms of the case itself, who we're working with, what involvement is going to be necessary on the referring counsel and that sort of a thing. There's a lot of other things that you could take into consideration, like, pro-hawking into another state, if that's what you're being asked to do. Like, for instance, the state of Montana only has 2 lifetime before you have to waive in. Florida, I think, has a 3 and a 2-year period max. So you just jump on one and then another or something like that. And all of a sudden you got one left and you're in trouble and one of them is going to settle anyway, So that's a small, not anecdotal, but a little bit of a consideration that we always keep in the back of our mind because we do things in other states. But generally speaking, I think, if you're getting those cases that are coming to you, it's obviously a good thing for you and your practice, but you got to be wise in which ones that you're taking. And just like you are with your clients, never overpromise and underdeliver. Try to underpromise, overdeliver on those sorts of things.
Yeah, that's helpful. So we've got a couple questions about structured settlements. As our listeners know, our presenting sponsor is Independent Life, the only plaintiff-focused structured settlement provider in the country. First question, what's the role for structured settlements in your complex cases? I know you've had a lot of huge cases that have resulted in a structured settlement. Why don't you talk a little bit about how a structure plays an important part in settling those cases?
Right. So, it can certainly help settle them by showing a number. And this is what defense lawyers try to do a lot of times, right? Show, hey, look, this number can really be a larger number over time. We don't even let our clients look at those, whether it's from anybody. I want you to look at the actual value of the case and what a jury would think the value of the case is. But it could, if you have a client who really wants to resolve a case, yeah, that could help you take this amount of money and turn it into this amount of money over a certain period of time. But moreover, it really provides a sense of security. It really is a guarantee secured future for these folks, right? You're handing them life-changing money. I can't tell you how many times clients had said no and turned it down, especially earlier in my career when I didn't have as good of client control, I think. And then 6 months later, they're broke, and it's a damn shame. But, I also have people that can turn, $15 million into, $40 million guaranteed plus investments from that 40 that'll turn into 100 over their lifetime, and it's like, when you know that you can do that, make sure that their houses are paid for, everything that they want, in their life is covered and that they are safe and secure after going through such a horrible experience that made their case worth that kind of money. It's obviously a no-brainer to do that. It really is. So
absolutely.
Yeah.
And on that note, Jason, we're going to say that you're actually one of the champions of structured settlements and attorney fee structures. For everyone that doesn't know, we ran a very successful webinar last year, and Jason was our guest attorney to come on and spoke a little bit about how attorney fee structures has helped him. So I'd like for you just to give a few tips, Jason, to our listeners on how, you personally have used attorney fee structures for your business and also maybe for yourself.
Right. So, That's a great question, and I appreciate the opportunity because I think it's very important. And COVID has proven that more than anything else that I could ever state to anyone who's listening to this right now. On that podcast, I ran the risk of sounding like arrogant, I think, because people are suffering, they're waiting for PPP money. And I said, I'm really not worried because I've got years of my overhead covered on my personal side and my business side because I have utilized the structures and annuitizing my fees over time. And that is, I mean, there is no better feeling than knowing that I have until this day or this month in this year before my money runs out. And oh, by the way, I'm adding to it off of this case. I'm adding to it off of this case. I bought another lake house, or I bought a lake house, another house in Tennessee 2 months ago. I got a case coming in. I'm going to add to my current annuities to cover that mortgage on the new house. I don't have to figure out how I'm paying for that. I know how I'm paying for it. So that is a really tremendous tool to be able to, protect you and your family. But also there are things that I don't think people realize how it works, right? Like you get qualified settlement funds set up for client A, and you get one for client B, and you get one for client C. And it might only be a $500,000 case, right? You got a $200,000 fee sitting in there. Well, if I don't need that money and it's November, if I have it in my operating account and it comes January 1, I'm getting hit with tax. But I could leave that in there until January 1, and I have a bunch of these QSFs added up, and I could then use it to fund my payroll or other bills that I need and draw and wire from the QSF without having to pay tax on the money, because now I'm getting it and I'm getting the full 100% use of it in that taxable year. So it's not going to be considered earned income. It's in the door, out the door. So that is something that I've been working on as well over the years, is building up those QSFs. So I know I've got 10 months of payroll, I've got 12 months of payroll. Then it becomes starting to annuitize those as well. So you've got your personal side, you've got your business side, and to be able, that's at least how I look at it. And it is such a relief in terms of running a law firm. I mean, look, our jobs are stressful enough, right? It's hard enough to do what we do. And it's a very high risk business. You get a good enough case, and I hate saying that, good enough case. That's the trap that I fell into for years and years early on in my career. I was waiting for the giant case to go ahead and do it. And the reality is, like I gave you the example before, if you have a $500,000 case, a $300,000 case, well, if you settle 5 or 10 of those, right, or 6 or 13 of those, and you're leaving a lot of that money in the QSF, at the end of the year, you can pull them all together and fund one giant annuity for your family that may go another year or 2 years. So the mistake that I got into was waiting until I had a really big case, like, oh, well, I need the money for payroll, I need the money for this and that. And, it wasn't until years ago that I was kind of jammed in my head by a couple friends, do it. And I did it, and I never looked back. That's all I look at now, is what's in my QSFs, what's in the annuities, and how long are they going to go for? And I'm telling you, that is it's a relieving, after going years of building a law firm straight out of law school, adding a lawyer here, a lawyer there, trying cases, losing some, winning this one or that one, it's like the stress of that ride. It's pretty crazy. And, when you get to a point where it's like, you don't need the money right now, you don't actually need it. There's a real great deal of freedom in that.
Well, that was perfectly said, Jason. We probably couldn't have said it better ourselves. And as you said, we always said to other attorneys, you have this stuff set up so that you can actually focus on your clients and focus fighting for justice, instead of trying to be a financial planner as well for yourself and a business owner. So it's very smart. We are down to our last question. Time flies when you're having fun.
Right.
Jason, what is something that you know now that you wish you knew 5 to 10 years ago as an attorney?
It's a good question. If I could look back 5 to 10, well, frankly, I mean, I'll be honest with you. I know that Independent Life is a sponsor of this, and I do use Independent Life, but that is the first thing that pops out in my head. I mean, that really is a big deal. When you start to structure your money and you have a guarantee, that takes so much pressure. Like you said, I mean, you get to not only focus on your clients, but it's like, I don't worry about payroll coming up. I don't worry about mortgages coming up. And, back 10 years ago, 12 years ago, I would be worried, right? It'd be, okay, where's the next big case coming from? And I'll also tell you, it provides you an ability. Look, we're all human beings, right? If you have a case that you think you might be able to hit for $5 to $10 million in front of a jury, and they've got $700,000 on the table indicating that they might go to 112, it is almost in your own human nature and in your own benefit, if you're struggling as well, to show your client just how much money that is life-changing money. Whereas when you're in a position where, you know, everything's covered and taken care of and you have planned for that future, you know, suddenly it's like, all right, look, I know 500 grand is my worst day in court with interest. I'm beating that 700. Don't even continue negotiating. Let's just go try this thing. And that's when you wind up with the 7.5, or you wind up with this larger verdict, right? And then things start to cascade into bigger numbers in settlement, bigger cases coming in the door. It's the way it goes. I mean, I had a friend of mine tell me, after I got my first 8-figure case, he said, trust me, it's just going to keep coming. And I was like, well, we'll see. And sure enough, I mean, I've got a lot of them that I'm working on. So I think it's a lot of things, but that would be probably the most crucial one for me, was learning to take care of myself financially. I was always taking risk. I was always reinvesting in the business and trying to grow it, but not maybe in the most financially sound way in my career. I was always taking huge risks, but I guess with huge risk comes huge reward, right? But yeah, so I think planning that out, giving yourself an opportunity to try those bigger cases, that's a piece of advice that I would give any young lawyer.
So, Jason, we've asked that question of every guest that's come on Settlement Nation, and that is by far my favorite answer that we've
Mine
received.
too.
And it will be very difficult to top. So, thank you very much. Well, Jason, thank you again for joining us. I think this was a great conversation. I think our listeners are going to get a lot out of it. If any of our listeners want to reach out to you, maybe co-counsel a case with you, or just pick your brain on something, what's the best way for them to reach out to you?
Yeah, you can always reach us on our website, jordanlaw.com, at our phone number, 303-INJURED. That's the office. But you can always, if any lawyer needs to text me or just even talk about cases, I'm always open to people. You can call me on my cell phone or text me, 720-951-2985.
Thanks so much. Don't be afraid to reach out to Jason. He's a great guy. And if you have not liked or subscribed or reviewed our podcasts on Apple or Spotify, please take a minute to do that. That really helps our searchability, our rankings. We're currently top 3 for trial lawyer searches on podcasts for Apple. So we are climbing the charts, and it's thanks to great guests like Jason. So Jason, thanks again for joining us.
Thanks for having me.